Thank you all for coming. I want to welcome you to the seminar on advanced trial techniques for the Moore advocates here at Fordham Law School and the graduates of Moore advocates, both current students and alums. I see groups of both of you out there. First of all, I want to thank Justice Douglas McKeon for planning this seminar. Tonight is the first of two nights. We've now confirmed that our second night will be October 3rd. And on October 3rd, we will have a seminar on openings and summations. We will have Harold Price-Farringer and his partner, Erica Dubnow, and our own Judy Livingston will be joining us. We've kind of adopted her, even though she's not a Fordham alum, but she's married to Tom, and Tom, of course, helped to create this program. I guess I told you, Judge, that I was going to allow you to introduce our distinguished guests, but I just want to point out to you that Justice McKeon insisted on getting us only the best in New York, and probably only the best nationally. Tonight we'll be focusing on direct examination and on cross-examination. And the only thing I can tell you is you're in for a treat and an enormous learning experience. So, I guess Doug is you first.
Actually, you're right on both counts, Greg. They are the best, and they're the best nationally. They belong to an august body that Judy Livingston belongs to, known as the Inner Circle. It's a national group of great trial lawyers from all over the country, really the cream of the crop. And, you know, as part of what we do here with the Moore advocates, I had a conversation with Tom Moore, who thought it might be a good thing to bring in some very seasoned, talented lawyers to share their insights on some of the things that go into being a successful trial lawyer, and to do it in a way that kind of is a relaxed atmosphere. Ask what questions you'd like. Feel free to have a dialogue with us, because we want this to be a sharing experience. Ben Rabinowitz and Evan Morgan have tried cases before me. They write, I guess it's monthly or periodically for the New York Law Journal. They are teachers of trial practice. Not only to judges, Evan and I are going to be up at the Judicial Institute in December, to other lawyers, to people who have any kind of an interest in this field. And so we thought tonight we'd give you a cross-section of different things that go into performing an effective direct and cross-examination. But from my own point of view, I want to share one word with you. It's a word that lawyers and judges and law students don't really equate with the notion of a trial lawyer. And the word is narrator. A trial lawyer is supposed to be a good narrator. And the reason I use narrator is because we can never forget, as trial lawyers, that we're telling somebody else's story. Many people in a courtroom lose sight of that fact, forget that fact, make themselves the story. Best trial lawyers are good at telling someone else's story. And no one does that better than Ben Rabinowitz and Evan Morgan. That part of a trial that puts before a finder of fact the ingredients by which a case will be decided is what direct and cross-examination is all about. And while simplistic on its face, one can never learn enough about it. And one ever learns about it with each and every year, each and every trial, and each and every experience in the courtroom. And if I can give one piece of advice, and I've given it before various audiences, be yourself. You're going to be impressed tonight, and take what you see tonight and incorporate it into yourself. Don't be an Elvis Presley imitator. Don't be somebody other than yourself. Because learning the basic ingredients is one part of it. Learning to be believable and credible to strangers, jurors, a judge, is the other. The second part requires the best of you. And so, let me introduce, yes, Ben, you're going to start off. Truly, one of the great trial lawyers, not only in New York, but in the country. And it goes for both of them. As I say, I've sat for many, many weeks with both. Some of the great verdicts here in the state were gotten in front of me by each of them. And so I can truly attest to their great skills and their ability to teach the subject matter. Ben Rabinowitz and Evan Torkin. Ben, you're going to...
All right, so we're going to talk tonight about direct examination and about cross-examination. And before we get into that, I want you to know who it is that is really talking to you tonight. I know you've heard about Judge McKeon, but what you don't know is this. We had an opportunity to participate as trial instructors many years ago, probably more than 20 years ago, right here up at Fordham. We were teaching for the City of New York, for the Assistant Corporation Counsel, the new lawyers who would come in and wanted to learn how to try a case. And Judge McKeon came in, and I remember thinking he came in to teach those new Assistant Corporation Counsels to try cases. Meanwhile, his courtroom happens to be the busiest courtroom, not just in the city or the state, but in the country. And he's devoted himself, ever since I've known him, to being up front and teaching all the lawyers that basically practice before him now. So you can imagine what happens. We start off learning from him, and now we're teaching with him. And I got to say, Judge, it's an honor to be with you, to teach with you. As far as the Moore advocates, I will tell you this. I have known Tom Moore for many years, in fact, as long as I've been practicing law, and I know Evan has as well. And his partner, Judy Livingston, happened to go to school with me, although it wasn't Fordham. I like the way that you've adopted her. That's a good thing. I will tell you this. There are few lawyers that I know that are better than Tom and Judy. And the thing that I like most about them is they're always willing to help. In fact, when I'm stuck on trial and there's no one else to turn to, I'll call Tom, and he always, even though he's in the midst of a trial, he'll always pick up the phone and talk to me. So I really know that you're in for a treat when you see those lawyers come before you. So let's go back to direct examination. That's where we'll start tonight. And if I ask you this, you know I'm talking about direct examination now, cross-examination too. What's the most important part of the trial? What do you think? I'm talking about direct and cross. What's the most important part? What do you think? Oh, what is it? What's the most important? The singular most important part. How about that? What's the most important part?
The jury verdict.
That's the right answer, right? Of course it's the right answer. It's the only thing that matters to your client. It's the verdict, right? So the question is, how do you get to the verdict that you want? Judge McKeon just stood here and told you about narrating or telling a story. But how about convincing people that what you're saying is right, and the way that you say it is as important because you want to come up with a righteous indignation that holds on to the jurors, and you're not going to let go until you know that you've convinced them that your side is right. But if you think about it, have you ever come back from court, if you watch court, and say, that lawyer did a fantastic direct examination? Not a chance, right? What you're going to say is, that witness was great. Right? That's what's going to happen. Cross-examination, yeah, the lawyer was great. But not a direct examination. Why? Because the difference, and I'll start off with the basics right now, the difference between direct examination and cross-examination can be summed up this way. With direct examination, the lawyer hides in the background. The witness is the star. We want to point to that witness chair. We want all eyes on the witness chair. Cross-examination, the opposite. All eyes on us. All we want from the witness chair is a bobbing head agreeing with us, yes or no. That's all we need, right? To win the case. So think of it this way. If you're conducting a direct examination, and you're conducting it properly, well, you know that that witness can't say one word until you allow the witness to speak. So if you think of it, you're the director, you're the producer. And if you're the director or the producer, the only time that you ever hear comments about you as a lawyer is very much like a baseball game. Think about it like an umpire, almost the World Series time. When do you ever hear about an umpire in a baseball game? When they screw up, right? That's when you hear about it. So if you screw up, you can be sure they'll comment on your direct examination. But if you do it right, they're focused on what a great witness that was. So how do we make that witness great? Well, I suppose I should tell you this. There are a number of types of direct examination. if we're really being fair and talking about direct examination as a whole. There's narrative direct, there's adverse direct, there's hostile direct. Hostile and adverse direct, we can really deal with cross-examination. That's what we call the adverse witness to the stand. And we start off by leading questions. We ask the witness only leading questions. We can do that, for example, in a medical negligence case, I'll call the target defendant to the stand. And that way we'll lead and we'll get a lot of information out that way. Let's put that aside for just a moment. Let's talk about the narrative direct examination. The question is, how do we force the witness to narrate? Judge McKeon just spoke to you about narration, telling the story. How do we force the witness to narrate? Well, one of the ways is to ask questions that you learned when you were in grade school, perhaps junior high school, all those journalistic questions, the questions that force the narrative. And there are the good questions on the one side, the bad questions on the other for narrative direct. Think of it this way. If I asked you as a journalist, what were the questions that were important? You tell me the who, what, when, where, how, describe, explain, all of those questions, right? One question I didn't mention just now is why. Hold off on that for just a moment. But who, what, when, where, how, describe, explain, tell us in detail, tell us step by step what happened. In other words, these are the ways that the witness has to give you a narrative response. If you use words such as did, were, have, had, could, should, and the opposites, did, didn't, were, weren't, have, haven't, all of those questions call for a yes or no. Are you wearing a blue shirt? It's either a yes or a no. If we had to change it around to non-leading forms, what color shirt are you wearing? The witness has to respond. So we know that there are ways of doing it. So now you get to the whole area of this. What is a leading question? I know you all think it's when you ask a question that suggests the answer. Not true. There's more to it than that. A leading question is a question that suggests the answer, or one that severely limits the universe of potential answers. So what about this? Let's assume I have Judge McKeon as the judge. I ask a question. Were you wearing a blue shirt or was it a light blue shirt? Objection, leading. All right. Given a choice, perhaps it went that way. What happens if it goes the other way? What are you going to do? You got to get yourself out of it. It doesn't make a difference is what I'm saying. You as the trial lawyer have to know how to get out of the problem of leading at all times. If you've severely limited the universe of potential answers, if it's sustained, you have to ask another one. If it's overruled, great. But the point that I'm making is you have that list of questions with you. The who, what, when, where, how, describe, explain. You didn't even say tell us what color shirt you're wearing. Describe the color shirt. In other words, what you're doing is you're forcing the witness to narrate, and that's what we want at all times. If you take a look at the federal rules, I know some of you have studied that. Anybody? Remember the federal rules? It's good that you know that. I'm glad some of you. Okay. There's a rule, Federal Rule 611C, for those of you who practice in federal court. And I have to say, I hate being in federal court. If I can stay out of it, I will. They don't let you roam like we like to roam. At any rate, in the federal rules, yes, a leading question is defined just as that, one that suggests the answer, but they actually have exceptions. All of these federal rules have exceptions, as you know. And they say you can lead when it concerns matters that are not in dispute. Why? Because they don't want to waste court time. And two, when it is pedigree information. So I could bring out pedigree information. You live in New York City, you lived here for 20 years. In fact, you were injured on a specific day, June 12th. Now we get to the heart of it. Now, in some courts, they'll let you do that. Often they won't. You just have to know when they're going to do it and when they won't. The point that I'm making, though, and I come back to this, is you have to know how to hurdle the leading question objection at all times. Because if you show your adversary that I can change any question around from leading to non-leading instantly, guess what? They're going to stop objecting because they get no mileage with it. You're only waking the jury up by an objection. Now they're focused again. They're not bored. Something happened that's important, and now they're going to listen. Believe me, you're teaching your adversary a lesson at the same time. All right, so let's assume we get past the leading question objection. And now we want to move forward with the direct. We want to continue with exactly what Judge McKeon said, which is we want to illustrate, we want to narrate a certain area. How's the best way to do that? What can we do on direct examination? We can use transitions. And if you use transitions, what you're doing is you're allowing the trier of fact to come in and know exactly where it is that you want them to be focused on. You want the jury to focus on certain things. So there are ways of transitioning. One of the easiest ways is what we call, Evan and I have written about this, something called the date, time, and place approach. You take two of the three and you ask about the third. So Jim, if I ask you this, let me direct your attention to June 12th, 2013 at 12 noon. Where were you?
Oh, yeah.
You gave me an answer. I got an answer there. Supposing I wanted to do it the other way around, right? Let me direct your attention to June 12th, Long Island. What time did you arrive in Long Island?
At 10 a.m.
So what I'm doing is I'm taking two of the three and I'm working on the third, the question. It doesn't matter. Date, time, and place. Let me direct your attention to the date and time. Let me direct your attention to the date and place, and I ask about the third. But it doesn't have to be that way at all. In a medical negligence case, for example, that I might be trying, doctor, I'd like to direct your attention to the point in time when the pulse oximetry reading dropped from 100 to 85. Who was in the operating room at that time? In other words, you're basically leading with the transition, and then you're asking for information that actually enhances for the jurors understanding where it is that you want to go. And that's what we're looking to do. We're looking to grab the jurors' attention at all times, to hold on to it, and to make sure that we have it. So if you use the transitions properly, I'm telling you it's a very important fact for you. Now, one of the other things that we can do is we can use the singular most important thing that I can tell you about.
And the idea of a transition, you're trying to, you know, a direct examination sometimes, as you pointed out, is not, you know, as gripping and exciting as the cross. And so you're kind of giving the jury a kick in the butt in a way by introducing and calling their attention what's to follow.
Exactly. If you can continually use them, think of it like a head note. If you were outlining something in one of your courses, and you had a head note where you wanted to say, for example, now we have to focus on pain and suffering, we have to focus on blood and guts, we have to focus on something that's important to your case, or to show, for example, why somebody is or is not guilty of a crime. What you're doing is you're highlighting a certain area that becomes crucial. I want to direct your attention to the point in time when the defendant took the gun out of his pocket. Where were you? In other words, what you're doing is you're showing something that's important, as the judge is saying, and then we can move forward from that point on. All right, a couple of other points that I'm going to make, and then I'm going to turn this over. But let's think about this. I was starting to say that the singular most important thing you could do, whether it's direct or cross, it's a simple thing when you think about it. But the most important thing that a trial lawyer can do, and I mean this, any trial lawyer at any time, is, you'll laugh when I say it, but it's true, is to listen. And the reason I say that is, too many times what happens is we come into court, and you'll notice, Evan and I don't particularly like to use notes, and neither does Judge McKean. Notes sort of get in the way. Why? Lawyers are pad bound, and they like to come up with pads. And what happens is you prepare your questions and answers, you go over it with the witness, you go over it so many times that the direct examination goes something like this when you finally come into court. Where do you live? Answer, 2 children. How many children do you have? 16 and 18. How old are they? Yes, it was a heart attack. And everybody's going, what in the world are you talking about? It makes no sense. The point is, you've got to continually listen. Now, that was a gross example, but how about something like this? Typical question in almost every case. Describe the traffic conditions. Answer, traffic was good. What happened next? What does that mean? Traffic was good. So you follow up. Tell us what you mean by good. I mean, it was normal, okay? What happened then? You still haven't gotten any answer. It's up to you. Or, for example, describe the man. He was tall. What did he do next? Wait a second. If you don't ask what happened then, if I ask my grandmother, describe a tall man, she'll, oh, you're a giant. You know, she might think so. It doesn't mean anything. The point that I'm making is you've got to listen to every single answer and evaluate it with one thing in mind. And this is crucial. And I'll repeat this again and again throughout the talk that I give. And this is the one thing. If you're doing a direct examination, in fact, if you're doing a cross-examination, you have to continually say this to yourself. Do I have enough information brought out to support my argument on summation? Everything is done with an eye toward summation. Make no mistake about it. Every single question that you ask, you have to determine whether or not you've gotten sufficient ammunition to strengthen your summation. If you do, great. But if not, don't even think about it. You've got to stay with the question and answer until you get something to assist you, to help you for your summation. Now, I'll show you one other thing as we move through this. I'm going to try and bump it up from basics to much more advanced. I know that's what we wanted. We will. think of it this way. There is something called the double direct, or looping. In every trial, there is something that becomes very important. There are certain facts that become very important to you. And those facts are the facts that you really want to emphasize. And I mean it, you don't want to emphasize those facts one time or a few times. You really want to show why something is so important. So what you can do is, you can take a little bit of the answer, and you can work in your next question right into the answer. So if I'm cross-examining Evan does, direct examining Evan. He doesn't even know what I'm going to do right now, but I'll take whatever answer he gives me, and I'll work through this double direct. And I'm telling you, it's a very powerful way. You can't abuse it, but every once in a while it's important. Mr. Torgan, I'd like to direct your attention to New Year's Eve, just before 12 midnight. Where were you?
I was in a bar.
Tell us what happened when you were at the bar at that time.
Somebody grabbed me by the throat and pulled the knife.
Before that person grabbed you by the throat, where were you?
I was talking to his girlfriend.
When you were talking to his girlfriend, tell us exactly what happened.
Well, she told me that she thought I was really cute. You didn't like that? It was a long time ago.
Mr. Torgan, after you spoke with his girlfriend, tell us exactly what the man did as he approached.
The man came up to me, pulled my hair, and he thrust the knife into my shoulder.
See what I'm talking about? What we're doing is we're trying to make a direct examination interesting by changing the tone of your voice, moving forward, and turning the thrust over to the witness if you can. It's a very powerful way of doing it. Now, I'm going to give you one other point before I stop. I'll have Evan come up and talk to you about direct for a little while. That's okay. Here's one of the points that I really want to make. You're studying to be lawyers. You're studying to be trial lawyers. You know what a leading question is. You know what hearsay is, or you should. You know whether or not something should be sustained or not. Every once in a while, you're going to ask a question like this. Suppose I ask, describe the man's face. Objection, leading. Is that a leading question? No, right? I haven't suggested what the man's face looked like. Describe the man's face. Objection, leading. Sustained, counsel, don't lead. Yeah, you could go up, Judge, you ought to take a trial techniques course to really know what the hell you're doing. Now, my point to you is don't argue with the court. I've gotten a lot of mileage with this in my trial life. I never want to argue with the court. So what? The judge made a mistake. I will never embarrass the court. Only one rule of trial advocacy: don't piss off the court. That's the truth. Move forward. Tell us what color hair he had. Tell us what color eyes he had. Describe the man's face in detail. In other words, you come back to it. But don't try and embarrass the court. And don't argue with something that you don't have to argue about. Just try and rephrase it. And I'm telling you, you get a lot of mileage. All right, let me stop for a little while. Have Evan talk to you for a little while about direct.
Let me just make one suggestion apropos of what Ed said about listening to a witness. Watch Charlie Rose do an interview from the perspective of a good direct examination, and watch how the good interviewer asks the next question based on the answer that he or she was given. If you do that, it's a very, very interesting study, and the art of direct examination is very much akin to the art of being a good interviewer. So, keep that.
That's a good one. I hope I remember to do it. Hi, everybody. Thanks for coming out. Appreciate it very much. So I got out of law school in 1982, but it seems like only yesterday. But when I was in school, I had this recurring dream that I was going to a final exam. I was totally unprepared, and I had no idea what the exam was. Does anybody have that dream? So, I'd like you to know that it never changes. Now I have a recurring dream where I'm about to do a direct examination in a case I've never heard of, a witness I've never seen. Add to that, I'm making it. So it's really bad. But my point is, if you use the tools that Ben just told you about, it doesn't matter who the witness is, if you know the case or if you don't. If you're prepared or if you're not, and I'm not telling you not to be prepared because you should. So there's who, what, where, when, and I say why and how. It's critical stuff. I mean, I know you learn it in trial advocacy, and I know it may be very basic to you, but I'm telling you, it will pull you through your trial career in very good stead. So you can see a witness, have no idea who they are, and just with the use of who, what, where, when, why, and how, with the transitionals that Ben told you about, and I'll add a couple more, you can do it direct. What's your name? Where do you live? How long have you lived there? Who are you married to? How long have you been married? How many children do you have? Look at that. That's the pedigree right then and there. But as the judge said a few minutes ago, it can get really boring doing that. Now you need transitionals. So you got to be able to take the person to another place or another time. So use transitionals. Ben used the one I direct your attention to, May 22nd, 2011. Where were you at that time? That usually gets the director to a very, very good start. Because first of all, talking about inflection, you've got to make it dramatic. I mean, it's not a dramatic question. It's not. But how about doing it this way? Sir, I direct your attention to May 22nd, 2011, and I ask you, where were you at that time? So there's no drama in it. You make it sound like it's dramatic. When you get the answer, then you go back like Ben did to the who, what, where, when, why, or how. All non-leading, all open-ended, all questions that will get the witness to talk, so that you're in the background. A couple other transitions I would mention that have kept me in good stead, even when I tried case before the judge, who I assure you, you really don't want him angry at you. Of all the judges. And he wasn't angry at me until the end, right? But I learned my lesson. Obviously I haven't. Where was I? I was talking about transition. Yes. Yeah, the motion to set aside the verdict. But now the use of transitionals, and I'm talking about transitionals that sound really convoluted, but they're language of direct examination that they know in New York in federal court. So you learn the major transitional that I suggest you only use once or twice. I direct your attention to. The other transitionals are things like, did there come a time that? Now that sounds really stupid, and it sounds really old-fashioned, and it's very wordy. But it's a word of transition, or a sentence of transition, that all the judges in New York know as being okay, even though it's technically leading. And all your adversaries will know is okay, although technically leading. And the rule is that you can lead when you're making a transition. So, did there come a time that? Did there come a time that you left the bar? Did there come a time, doctor, that you actually put in the suture? Did there come a time that you ended up, ma'am, in the hospital? All that stuff, you're going to say, Evan, that's a leading question, and it is. But it's a word of transition. So or a sentence of transition. The other thing that I would add is, it gets really boring when you're talking to witnesses, and you continue to say, what happened next? You've all learned that, right? It's great. I mean, it's great. What happened next? What happened next? What happened next? Ma'am, what happened next? Like, how good can you make that sound? You can change it to what happened then, but every once in a while, when you have a reluctant witness, or you have a witness who isn't volunteering so well, how about words like this? Continue. Proceed. Go on. What happened next? So, all you need to
just
know.
ask you a question.
Sure.
Obviously, some preparation has happened with you and the witness before that witness ever goes into the courtroom. And I would assume in preparing certain witnesses, you come to the conclusion, gee, this guy's done. And, you know, he's going to do a terrible job of telling this story. How do you adjust yourself to that, you know, reality and prepare yourself to elicit something from somebody who isn't going to give you an awful lot coming out of his mouth?
That's true. The truth of the matter is, there are no bad witnesses, there are only bad lawyers. Let that sink in. It's our job to make sure these witnesses put their best foot forward. So preparation is a very, very important element. When you have a friendly witness, which you don't always have, but your direct examination of your client or a witness who's coming in voluntarily should be very, very well prepared and gone over. To the point where you never want it to sound rehearsed, but you're committing malpractice if you haven't sat down and turned the witness into somebody who can tell a story that's somewhat compelling. And the way I would do it is, I would actually go through the direct examination, and I would go through it. Now, you don't want the witness to get stale, you don't want it to get rehearsed, don't want it to get old. But you really do have to go through the direct. And for example, with questions like transitionals, I would explain to them what type of answer I'm specifically looking for on that transition. So for example, I direct your attention to May 11th, 2011, where were you at that time? And you say Long Island, that's not going to help me, it's not specific enough. So I would let the witness know about where I would want to go. And as long as it's truthful testimony, it's fine. So that kind of preparation is good. One of the best things you could do, though, is thinking about cross-examination. And there's nobody better in preparing a witness for cross than Ben, because Ben will cross-examine the hell out of his own witnesses. And there's nobody who can cross better. So that witness will be very, very well prepared for cross, and very, very well prepared for direct, based upon that.
All right. Here's what I'd like to do right now. I want to talk to you about some of the basics of cross-examination. We've actually brought some exhibits with us, so Evan, I just ask you to get the scene exhibit, the street.
The what example?
Scene. All right, so let's focus on cross-examination for a little while. So we live to cross-examine. That's everything in trial law. You gotta love cross-examination because you're in complete control.
But before you do that, let me ask you, I mean, one of the things that is incorporated in direct from time to time is that you're doing the mechanical job of laying the foundation for exhibits, for evidence that you want to introduce. How do you work that in with your preparation of the witness in direct examination so that they give you the right kind of answer so that you can get an important exhibit evidence?
Right. One of the things that Judge McKeon just asked about was how do we lay the appropriate foundation for this? But the prep of the witness is something you very rarely hear about with lawyers. I will tell you this, in my office I spend an awful lot of time with my own witness. And as far as cross-examining my witness, yeah, you could be sure the witness, when they come into court, it's going to be an easy job for them to handle cross-examination because of the way that they can cross-examine in the office. I want them to understand what's coming, and I want them to know what's coming. As far as laying the foundation for the exhibits, which is certainly something we're going to cover in just a little while, and we will, but I want you to understand also that you have to go through each thing. I mentioned before how I don't want you to be pad bound, but I certainly don't mind you coming up with a pad, for example, with bullet points, things that you have to bring out. Yes, it's true, when you're laying a foundation for the admission, the admissibility of, for example, a photograph, there are leading questions that you're going to ask. They're permissible. It's a certain litany of questions that you must ask for the admission. We'll show you those also. We'll be doing all of those right now. Let me just turn back, if I may, just for a moment to cross, though.
Let me say this. You know, when you listen to the Tom Moores and the Ben Rabinowiches and the Evan Toggins who are at the top of their game, they say don't use the pen. Well, listen, there are a lot of successful people out there who, one of them was before me today, Stephen Gallis, who reads his opening. And you know something? He's been successful. So that if you need to use a pad, it's not necessarily a fatal thing to do. And it goes back to what I said when I began. You have to stay within yourself and make the very best of your skills in a courtroom. Today, not everybody that's successful is a great orator at the level of these gentlemen or some of the others who you'll hear in the next couple of weeks. So you can be effective using some of what Ben Rabinowitz would believe to be a crutch, but nonetheless, if that works for you and you do it well, you'll be very, very successful.
By the way, he did not invite that lawyer here. No, the guy's a great lawyer.
Steve Gallis will do one thing, and I will tell you this. I know him well. And if you're going to use the pads, the one thing Steve will do is he will listen anyway. The reason I'm concerned about using pads is, I'm telling you, I've watched the big firm lawyers come in. They're so well prepared. They've rehearsed it so much. Everybody knows exactly what the next question is. And guess what? If you screw up by not asking one question, now you've thrown everybody off. You can't do it that way. I don't care if you're using a pad or not. The bottom line is you have to look at the witness. You have to see the eye contact. And the reason I say this is it's twofold. Number one, if you're doing a direct examination and you ask, what happened next? The question that Evan was saying, and the witness says, he went like that. Tell us what happened after that. you have nothing to protect the record. And that's why I'm saying, unless you're watching, unless you're seeing what's going on, you get your head out of the pad, you have to let the record reflect something. Your Honor, may the record reflect that he lifted his right hand up and held his thumb and index finger out in the shape of a gun, whatever it happens to be. So obviously what Judge McKeon's saying is right, you've got to temper it a certain way.
Well, that's because a good direct examination is a good conversation.
That's right.
And, you know, you're listening to the answer and you're responding appropriately with something that flows from there. And much of that is, needless to say, preparation. But of course, there's a certain spontaneity, if it exists, that makes a direct examination better than the norm.
I can't tell you how many times you're going to see this if you're ever writing an appeal, where the question is asked something like this: what happened next? The man went like this, and then he went like that. And guess what? Your appeal record reflects nothing. So unless you're taking care of protecting the record, as far as I'm concerned, I'm very tough on this. With the lawyers in my office, I'm really tough. If you do something like that, you've got to re-educate you, because you have not given us enough to work with.
If I may then, we see it all the time with depositions. You get a deposition and you get an answer like that, and it's usually the lawyer doing the trial is not the one doing the deposition. We have no idea what he just pointed at or what this and that means. So what Ben is saying holds true, not just the trial for appeals, but in discovery, everything that you do as a lawyer. I'm sorry, go ahead.
Right. Now, one of the things that I'm talking about with listening sort of transitions well into this and segues well into what I wanted to talk to you about for cross-examination. Because in cross, yes, you become the star. You want everyone focused on what it is that you're saying. Like I said before, all we want is that bobbing head from the witness chair.
By the way, does anybody have any questions on direct that, you know,
Yep.
might be a good time to...
We're coming back to it, I assure you, but if you don't have any questions, we'll take them. Okay. Yes?
What happens when you ask a question, you anticipate a certain answer from your witness, and the witness says something completely different from what you heard when you were recovering evidence before trial? What do you do? That's the direct.
Okay.
You contact your malpractice counsel.
It happens all the time. I'm going to show you something. You know, since this is I was told to make it an advanced class, I'm going to get there, and I'm going to get there right now. Let's assume Jim's my witness. Okay? And I want Jim to say the man was holding a gun in his hand, but he doesn't come close to doing that. And I'm asking everything. So Jim, just work with me. Don't say he's holding a gun. I want to direct your attention to the man's hands. Tell us what was in his hands at that point in time.
It's something.
Let me just focus your attention on his right hand at that moment. What was in his hand? Was he holding a gun? Objection, leave it. Let me ask you this. What was in his hand? Now, that's reality. You're not going to read about it, but that is reality. Now, it's a gross example of what I'm talking about, but I think it answers your question, because what I'm trying to do is this. No kidding around, right? We'll try it as hard as we can. Let me repeat the question. Let me try that again. Perhaps my question wasn't clear. It's always good to be self-deprecating. Perhaps I didn't make that question clear. Tell us exactly where you were at 2 p.m. You guys. Let me direct your attention to 2 p.m. specifically at the school. 4th floor, room 320, you know? In other words, you got to take control, but you can't leave the area. And that's what I was talking about before. In other words, you have to evaluate the point so much so that you can say to yourself, have I made the point for summation? Because you can't let it go. And that's just what Evan was talking about a moment ago. If He went like this and like that. That doesn't help me. It doesn't help me in a deposition. It doesn't help you for a readback later on. And it certainly doesn't help you in the event your case is appealed to the appellate division, and no one knows what this and that meant. So it's up to you, again, to take hold of the witness.
Ben, could I just give a different example of the gun? So the witness will not say anything about the gun. He won't say anything about the gun. Now, you're advanced trial lawyers already based upon the courses you've taken. So you know this question, what, if anything, is this non-leading is against, right? What, if anything? What could be more non-leading like that than that? So he won't tell you the guy has a gun in his hand. How about this? What, if anything, did you see with respect to the gun in his hand? Objection, leading. Judge, I said, what, if anything? Okay, let me do it again. What, if anything, did you see in his hand? Right? So the point is, it's not good to have to do that, but it's better than not getting the answer that you need to lose the case. I'm sorry.
No, that's exactly the point.
This also takes you to something that I think is just good, generally speaking. If you know you're going to be before a certain judge and trying your case, walk into the courtroom and watch that judge in somebody else's case. Get an idea as to who that person is, how liberal they are and how the courtroom operates. Get a sense, a feel for things. And it's going to shape how you respond to adversity in the courtroom. Certainly what you don't want to see is flustered at an answer that you hadn't expected.
It's an interesting thing that Judge McKeon mentions. I remember when I first started out, you try cases in state court, you try cases in federal court. In federal court, courtrooms are beautiful. They have a lot of money and they have these gorgeous left turns. And in fact, the judges want you to stay behind the left turns and touch them at all times. If you leave the left turn somehow, that's improper. In state court, a lot of the courtrooms don't even have left turns. They can't even afford to have left turns there. So you get used to speaking without left turns. And that's quite frankly where we grew up. And we are used to speaking without the left turns. But it's true, you need to find out who your judge is, what your judge likes, what they don't like. If you know the judge, you're that much better off. I always suggest that, and that's a very important point. Let's turn.
And you get a sense of the room also, as Ben said. How are you going to walk around? It's like being in a theater. It's important. Just get a better feel, a comfort level.
Sit in the jury box.
All right, so let's talk about cross-examination right now. I tried to tell you just a moment ago that what we're looking to do is we're looking to have the focus switch from the witness to you. And it's going to depend upon the tone in which you ask the questions. And you'll see some of this. We're going to be doing some examples in a little while. But if you think about it, what we're really trying to do is we're trying to find ways to lead the witness. But there are ways of leading and there are ways of really leading the witness. And if you think about it this way, if I ask questions, I told you those other questions before, did, were, have, had, could, should, those are questions that call for a yes or no response. But that's not the kind of leading that I want to see in cross-examination. Because if you're doing cross-examination right, what we're really doing is we're telling the witness the answer instead of just asking the witness the question. And it's a powerful way of cross-examining. So for example, if I use you as my example and I wanted to know what color shirt and tie you had on, I could ask a question. What color tie were you wearing? And you tell me the color, right? Supposing I wanted to do it the other way around. Let's assume you have a red tie. You're wearing a red tie, true? Okay, how about this? There's no doubt about it. You were wearing a red tie, correct? In other words, you're telling the witness the answer. You're taking control. And it's something that you want to do all the time, especially if you're calling an adverse witness. You want to put them in their place, let them know that if they try and weasel out of it, for example, give me a long-winded answer. Isn't it a fact you were wearing a white shirt?
Well, yeah, I don't really remember.
Sir, my question is specific. You're wearing a white shirt, true?
Yes.
No doubt about that, correct?
No.
When you said you didn't remember a moment ago, can we agree that was slightly less than truthful? The point that I'm making is you're taking control, and you're not going to let go of that witness until you get the answer that you need. All right? There are certain answers, though, and I'm always concerned about when I see the questions that lawyers ask. How many times have you heard on cross-examination a lawyer asking a did you not question? I don't like that question. It's one of my pet peeves. You walked into this room, did you not? Give me an answer, yes or no.
Yes.
What does that mean? You walked into this room, did you not? Yes, I did not, or yes, I did. I don't want that. If that's the most important question that I've asked, and that's going to turn the jury verdict I don't want that one coming out. How about this one? The other question that I don't like. There are two of them, the did you not and the do you know question. Do you know if you walked into the room? What does that mean? It means that you know, but we don't know what happened. So stay away from those. In other words, we're telling the witness the answer instead of asking the witness the question. Now, there are some basics with this that I want to go through right now. And one of the things that
In other words, someone is, do you remember?
do you remember? Yeah, exactly the same thing. So those are the questions. If you listen, and that goes back to what we were saying before, if you listen, we're getting more mileage from it. So why not ask questions directly? And why not put the questions that really help us to the witnesses? So if we think about it this way, we want to be able to ask questions that almost pierce the heart of the witness when we're asking them. I told you a moment ago on direct examination, there are certain facts that become important. Well, in cross-examination, the same thing is true. There are certain facts that become really important. And if we work through what we call an expansive cross-examination, where we're taking a moment in time, we can freeze frame that moment in time. If you think about action, anything that ever happens in life, your entire life can be divided up into a series of moments where you string them together, sort of like the cells in a cartoon. For each individual cell, you put a question. It's a very powerful way of cross-examining. So if I illustrate that this way, just watch what I do. I try and fill it up with examples. Just watch what I do. If I say to you, do a direct examination on what I just did, what would your question be? Direct examination.
My question to you.
Yeah.
What did you see? My question.
Your question
You're
to
the
me.
witness.
I'm the witness.
What did you see the man do?
Drop his pen. If I changed it, I said cross-examination, what would your question be?
You saw him drop his pen.
Okay, you saw him drop his pen. True, that's telling me the answer. But that's not the mileage that I want. What I'm talking about, though, is I want to take it back in time. I want to freeze the moment. And if we freeze the moment, we bring it forward, it doesn't start off with the pen being dropped. It would start off someplace early. And you're going to change the tone of your voice, and you're going to move it along, step by step, until we get the answer we want, and then we grab the witness, and then we move forward. There was a pen in your pocket, true. You knew it was there. You knew it was blue. You started to reach for it. You touched it. You held it between two fingers. You knew at that point in time you were going to take your hand out of your pocket. And you did take it. And you held it all the way out. Between two fingers, you looked at the pen. You started to release your grip. You separated your fingers. The pen started to fall. And you, sir, did nothing to stop it from hitting the ground, right? In other words, we're getting mileage with it. And that's what we're trying to do. Because if we can get mileage, and I'm telling you, I've used this example in teaching for a number of years, but the point that I'm making is, why not grab hold of the witness? If there's something important, repetition wins cases. And if we win the case through repetition, we can get a lot more mileage, right? Now, I'll tell you this, there are two schools of thought on cross-examination. One is the baseball bat approach, and the other is the voice of reason approach. They're a little bit more advanced, right? But if you think through the baseball bat approach, what's the baseball bat approach? You've seen this lawyer stand up, you know the witness is a liar, and this is the way the lawyer starts off the question. You're full of shit, aren't you? It's not going to work. The witness is going to resist. What you want to do is you want to find a way to question the witness so that it's reasonable, where you're doing things that are ultimately reasonable. And we'll try and pull this up with some examples in just a moment. But what I'm trying to teach you first, and I know Evan and Judge McKeon are trying to teach this, the difference is the way that you lead, the way that you change the tone of your voice, and the way that you're setting yourself up for summation. So once again, I'm trying to get you to reinforce the key facts, to move it along, to make sure you have enough for summation.
Ben, let me ask you, what adjustments would you make, because you have done criminal, and what you've been speaking about tonight, criminal versus civil. Are there any nuanced adjustments you would make based on the subject matter? Because our group here does more than just civil cases, they do everything.
All right. The biggest adjustment I found from being, I started off as a prosecutor, and I did that for 3 years, and I had my 50 or so jury trials, and it was great, love that. But the biggest adjustment was, you can't mention the defendant, not testify. You can't talk about it. Well, in a civil case, guess what? I get to call the defendant as my witness. This was gold. Think about it. And I get to call the defendant. To me, What could be better? Well, obviously there are certain things that you have to work on. The most important thing, obviously, besides the fact that you get to call a defendant, is the burden of proof. We're dealing with proof beyond a reasonable doubt versus more likely than not. A feather lands on it, we win the case. So one of the things that we're trying to do is we're trying to condition the jurors right off the bat in jury selection as to the lowering of the burden of proof. It's not a criminal case. But as a prosecutor, on the other hand, you have to indoctrinate the jurors to the fact that, yes, there's that constant struggle. One side is always trying to lower the burden of proof, one side is always trying to raise it. A good criminal defense attorney would make it, you think they're going to be satisfied if somebody proves something to a mathematical certainty? No. They want it beyond all doubt. And that's right. And that's one of the things that's the big difference, as far as I'm concerned, the way that you have to deal with the burden of proof from civil to criminal.
But certainly, you touched on it at the beginning, more often than not, in a civil case, you are going to have your adversary on as your witness if you're a plaintiff's counsel. And so that's, that's an important ingredient that you need to have in your arsenal. In other words, to meet your burden of proof, or lay foundation for expert testimony. More often than not, in a civil case, if you're representing the plaintiff, that defendant is going to be called to the stand on your case.
Right, right. Now, let me just get a little bit more advanced, and I'll have Evan do a demonstration for you on a simple scenario. But one of the things that we deal with all the time, day in and day out, is dealing with expert witnesses. And I will tell you, in law school, we didn't have enough experience in teaching dealing with expert witnesses. In every single case that we try now, and I don't care if it was a criminal case, if it was a heavy criminal case, you had expert witnesses you had to deal with. Civil cases, as a matter of course, as a plaintiff's lawyer, we have to prove our case through expert witnesses. And the other side has to be good at cross-examining our witnesses, we have to be good at cross-examining their witnesses. But there are ways of cross-examining an expert witness. And this is something that I realized along with Evan, kept doing the same thing again and again, and we realized there's a way to set the witness up and to knock the witness down. And if you can set the witness up, we're sort of walking them out on a tightrope. We walk them out as far as we can. Boom, when they fall off, they fall into this canyon of doom. They cannot recover if you set them up right. And that's what we want to do. We want to set the witness up. So how do you set the witness up? Think of it this way. For any time that you're dealing with an expert witness, and this is as advanced as it gets in cross-examination. Any time you're dealing with an expert, you've got to take a look at what that expert's report says, first of all. And then more importantly, what it doesn't say that it should have said. Because the holes in the expert report are crucial to you. Something that's not there. You don't want to just jump to it and point out something is not there. What you want to do is you want to find a way to set the witness up first and then knock the witness down. So you want to, basically what we're doing is we're reinforcing the importance of the report itself. And there are words that we came up with to lock the expert in. And if you're going to write down anything in this, when you're dealing with experts, write down these 4 words. Full, fair, thorough, and complete. Full, fair, thorough, and complete. Jim, you're my witness. Let's assume you're an expert on anything. Let's assume you've rendered a report. If I ask a witness a question, and I come off as the voice of reason, I'm not going to take the baseball bat out. I'm not going to swing, you're full of shit. I want to get the witness to agree with me. I want to show everyone that this witness is sort of working with me. Doctor, you did a full examination, true?
Yes.
One that was fair, am I right?
Yes.
Certainly one that was thorough, true?
Yes.
And you would agree with me. In keeping with your standards, it was complete, correct? What's he going to say? No, I did a half-assed job? He can't say it, right? Even if he wanted to, he can't say it. Because he doesn't want to be made to look like a horse's ass. And no witness does. But that's sort of walking up one side of the ladder. Full, fair, thorough, and complete. Now we want to come down the other side of the ladder by locking the witness in. In other words, show him why you win. In other words, full, fair, thorough, and complete. We've already established that. To the extent that you, doctor, didn't do a full examination, that would be inappropriate, correct?
Yes.
To the extent it wasn't fair, that wouldn't be in keeping with your standards, would it?
I would never do an unfair.
And the reason you wouldn't do it is because it wouldn't be thorough, right?
That's correct.
And you certainly wouldn't do it because you would never render a report that was less than complete, right?
That's correct.
Because then your opinion would be less than valuable, true?
Yes.
And certainly if you rendered a less than valuable report, this jury ought to disregard your opinion, correct?
No, that's up to them.
Well, I'm asking you. So let's focus on you. If you rendered an opinion that was not complete, would you agree with me that they should disregard your opinion?
I would say so, yes.
Now I set him up. I got him to admit he's screwed. Right? The point that I'm making is, now, for anything that's missing in the report, guess what? We have something to work with. So let me show you how this is done. I actually,
Let me ask you
yeah.
this, Ben. I presume you're comparing a cross-examination with the idea in mind that the direct examination is going to be superb. So you're preparing for the worst-case scenario. What if the direct examination is lousy? And, they haven't accomplished very much at all. To what extent do you adjust your cross-examination to meet that reality?
this is, think about what's being said right now. This is exactly why I'm saying you cannot be pared down. And it's exactly the point that I was making before, because yes, a trial is a moving thing. As it's going on, it's growing. So if you know that they've screwed up, thank you for coming in. No further questions.
And you have to be prepared to do that,
Yes,
and not be afraid to do
that's right. That's right.
He would never be able to do that. He would never be able to.
All right. I happen to agree with that, though. Yeah, you're gonna take the points that you win on and sit down. There's an old saying: when you're winning,
which is not
walk
easy
out.
to do very often.
Yeah. When you're winning, sit down. Stop. Don't dig yourself a hole. All right. So Evan, why don't you work with the? We have a problem. Let me explain the problem, and I'll have Evan cross-examine you on this. Cross-examine me on it. Let's assume we have. In civil negligence cases, there is always something called an independent medical examination. The other side is entitled to evaluate my client. And they've evaluated my client, and here is a doctor who evaluated my client, and the doctor says basically that there's no evidence of a herniated disc. That's what the case is all about, typical case. And the doctor then says in the bottom, I'd like the opportunity to review the x-rays, the CTs, and the MRIs.
I fell in Joe Blow's restaurant. Obviously, Joe Blow doesn't know what I did as far as getting medical attention. So the law gives me an opportunity to have him examined by someone I choose so that I can contest and find out myself, in the mind of my examining doctor, how badly hurt this individual is.
So in this, for example, that the doctor who did the examination rendered an opinion without ever having the x-rays, the CTs, and the MRI scans. Now, you could, if you wanted to, go right for the kill. Doctor, you never looked at the MRI scans. But then you're not setting the witness up. And what I'm trying to tell you is, we want to set the witness up, walk the witness out on a tightrope, and then knock them off, not the other way around. So you set them up first, and then you move in for the kill. And it works much better, because what you're doing is you're succeeding in what we call the punitive aspect of the compensatory case. You're punishing the other side for what they didn't do. So Evan, why don't you cross-examine?
Bearing in mind that the independent medical examiner, more often than not, is going to say, this person's not hurt, or not hurt as badly as they claim.
That's exactly what the opinion was.
Right. So typically, the other side, out of fairness, gets to choose a doctor. The doctor is being paid by the defense or the insurance company. They're going to come in and write a report for the side. That's typically what happens. And here we have a report saying there's nothing wrong with the person's faking, the person's a malingerer, the person doesn't have a herniated disc. And by the way, at some point, I want to see the x-rays and the CAT scans and the MRIs, the only thing that would show a herniated disc. So that's what we have. Doctor, you just testified on direct examination that there's absolutely nothing wrong with my client. True?
And that's correct.
As a matter of fact, not only is there nothing wrong, but my client is actually a malingerer, right?
Your client is a malingerer.
And by malingerer, you're telling this jury under oath that she's faking her injuries, basically, right?
I couldn't have said it better. Shouldn't be in court.
Thank you, doctor. Now, by the way, this isn't your first time in court, is it?
No.
As a matter of fact, you've been in court many times. Right.
I've been qualified as an expert many times.
And each time you were qualified as an expert, you were paid as an expert. True?
Yes.
You were actually given money, right? Money to review a case. True?
Yes.
Money to look at the case, right?
Yes.
Money to come into court and render an opinion. True?
We're all paid, sir.
Sir, my question was about you being paid. And my question is, you are being paid today, right?
Yes.
And the entity that's paying you, by the way, is the defense sitting right here, true?
Yes.
Okay, let's get back to my cross-examination, sir. My question to you is, you believe yourself to be a very fair man, true?
Yes, I do.
And a very good doctor, right?
Thank you.
And a caring doctor, true?
Yes.
And you're somebody who certainly takes the time before they render an opinion, aren't you?
Yes, I do.
As a matter of fact, you take the time,
Thank you, sir.
and you did nothing to stop it. As a matter of fact, you take the time to actually do an examination, don't you?
Yes, I do.
Because it would be wrong for you not to examine a patient before you render an opinion, right?
That would be correct.
You would be wrong, right?
Right.
You wouldn't do that, would you?
No, I wouldn't render an opinion without examining the patient.
As a matter of fact, when you examine a patient, you want that examination to be a thorough examination, don't you?
Yes.
You want it to be a complete examination, right?
Yes.
You want it to be a full examination in terms of evaluating the whole person, right?
I do.
And you want it to be complete, don't you?
That's what I did, sir.
Now, persons don't come in and get treated without certain diagnostic tests, right?
There are times when we do clinical evaluation, there are times when we do diagnostic tests.
As a matter of fact, you've referred patients for diagnostic tests, haven't you?
I have.
And people who specifically have back injuries, you referred them for x-rays, true?
Right.
CAT scans, right?
Yes.
And MRIs, right?
Yes.
Now, you'd agree with me, sir, that to evaluate and determine whether a patient has what you called before a herniated disc, you would have to actually do what's called an MRI, true?
It's one of the modes of evaluating for that injury.
Well, an x-ray, for example, will only show bone, correct?
Right.
And an x-ray will only show a fracture of a bone, or a breaking of bone, won't it?
Yes.
But it won't show the soft tissues within the body, right?
An X-ray will not.
But an MRI will. True, doctor?
Right.
And you'd agree with me, sir, that in order to fully evaluate whether somebody has a herniated disc, and I'm not just talking about clinically, I'm talking about radiologically as well, you have to see the MRIs. True?
I would like to have seen them.
As a matter of fact, not only would you have liked to have seen them, you actually asked for them, didn't you?
I did.
As a matter of fact, doctor, you said, I would like the opportunity to review for x-rays, CT scans, and MRIs, right?
Yes.
You put that in writing, true?
Yes.
Did you tell Mr. Jones, your lawyer, that, hey, before I come into court, I want to see these MRIs? Did you tell him that?
I did make a request in the report.
You said, Mr. Jones, come on, before I'm going to render an opinion regarding this woman's life that can affect her entire life, and what this jury does, I'd like to see all the evidence. Didn't you say that to him?
I would have liked to have seen those reports.
You didn't see him, did you?
No.
As a matter of fact, not only did you not see him, you came to the opinion, without even seeing him, that she wasn't hurt at all. True?
Correct.
That she didn't have a herniated disc, right?
Yes.
You know, sir, there were MRIs in this case, right?
Yes.
As a matter of fact, you knew it, which is specifically why you asked for them, correct?
Yes.
And Your Honor, I'm going to show the witness plaintiff's wanted evidence with your permission.
You may, sir.
But before I do that, doctor, you're certainly familiar with the spine, aren't you?
Yes.
And although this is an evidence, Judge, I would like to say, ask the witness, first of all, this is anatomically correct, isn't it?
Yes.
Well, you're going to mark it for identification, of course.
Of course. Well, it's already marked. And this would aid us in understanding the parts of the body involved in the case, right?
I can't say whether it would be me, Mr. Chairman.
It would aid the jury, wouldn't it?
It might.
It would aid the court, right?
It might.
And it's something that you use, isn't it? Your Honor, I offer this in evidence, or for demonstrative purposes, or better. Well, you know that my client, Your Honor, you know that my client has been diagnosed with a herniated disc and what we call L4, L5, true?
Yes,
And basically, if we're looking at this, the way we determine where a disc would be herniated is we count up from the sacrum.
Well, what does L stand for, Dr. Rabinowitz?
it stands for a certain area of the lumbar spine.
It stands for lumbar vertebral body, correct?
It is the lumbar vertebral body referring to the intervertebral disc above and below it.
So L5, the body of L5, is what I'm pointing to the jury right now, correct?
Yes,
And the way we know that's L5, it's the one lumbar vertebrae above the sacrum, true?
Correct.
And the next vertebral body above that is L4, right?
that's right.
True. And the disc that's in between L4 and L5, that's the L4-5 disc, true?
It is.
Now you'd agree there's a certain radiological diagnosis of a herniated disc, true?
That's why I wanted to see the MRIs.
Well, let's show them to you now, doctor. You'd agree with me that the definition of a herniated disc is when the disc itself protrudes out beyond the vertebral end plate above and the vertebral end plate below. True?
When the annular ring is broken and the inside of the nucleus comes through.
Well, a disc is made up of two things, an annulus, correct?
Yes,
And a nucleus, true? And a herniated disc is when the nucleus comes through the broken annulus, true?
that's right.
But
like
radiological-
a chili donut, right?
Like a hamburger with ketchup, Judge. Getting back to my examination, Your Honor.
You may proceed, sir.
But I'm not talking about a clinical diagnosis, I'm talking about a radiological diagnosis. And the radiological diagnosis, because we're only looking on film, is when the disc protrudes, whether it's nucleus or annulus, beyond the vertebral end plate above and the vertebral end plate below. Right, doctor?
That's right.
And you'd agree with me, doctor, that what we're looking at here is the disc itself. True? That I'm pointing to the jury? The disc?
You are.
And you'd agree with me that the end of this disc that's out into the spinal canal is protruding. True?
There appears to be a slight protrusion.
It appears to be sticking out, right?
Slightly.
And it appears to be sticking out into the spinal canal, right?
Yes.
And by the definition, it's protruding beyond the vertebral end plate above and the vertebral end plate below. True?
That's correct.
And that's a herniated disc, at least radiologically, right? Yes?
I understand what you're asking.
My question was really simple. My question was, that's a herniated disc, at least radiologically. True?
Although doctors have a difference of opinion.
My question is very, very simple. It's a question to you, Dr. Rabinowitz. My question is, there's no doubt in your mind, in 100 million years, that this radiologically is a herniated disc, right?
Some would say bulge, some would say herniation, some might even say extrusion.
Well, an extrusion, doctor, an extrusion is a lot worse than a herniation, isn't it?
It is.
It means the disc material, the nucleus that you told the jury, has burst out of the annulus and is actually broken off from the parent disc, floating around in the spinal canal. Right, doctor? Yes?
That's correct.
That would be a tragedy, wouldn't it, doctor?
Yes.
Why? You're looking at Mr. Jones. Are you thinking, Mr. Jones, before you put me on the stand and paid me $10,000, maybe you should have let me see that? You thinking that, doctor? I withdraw the question. I have nothing further.
Okay. I'll make one comment on this. One of the things that you can do when we're talking about this area of full, fair, thorough, and complete, You can take it as far as you want. And it's interesting to me to watch Evan do this in 10 or 15 minutes. I can assure you this cross-examination would have taken probably 2 to 3 days. I've watched Evan do this kind of stuff.
Not in front of him.
But there's something else that I just want to point out to you. Anytime you have a witness, and we're getting a little bit more advanced here, but I'm trying to do that purposefully. Anytime you have a witness, whether it's a professor, a law professor, whether you have somebody who teaches, for example, a doctor, if they're working in a teaching hospital, an economist who teaches students at a university, whatever they do, look at how much better it is when you go into areas like that, because you can milk it for all it's worth. So if you took the same cross that Evan just did, and I'll just show you a little area of expansion, because that's what we're trying to show you, these different areas of permutations that you can use on the cross. If you say this, doctor, in this case, you specifically requested in your report, right here, to see the MRI scans, correct?
Yes, I did.
One of the things that you teach your students, the residents in the hospital, is to take a look at the available diagnostic studies, true?
Yes, I did.
And you tell them, find out if an MRI scan was taken, right?
What I say is, whatever you do, don't look at the MRI scans.
In fact, doctor, that's exactly what you would never do, right?
That's what I mean.
Because if you were to do that, now you go for the wind-up, if you were to do that, that would be a departure from good and accepted medical practice, wouldn't it? In fact, doctor, if you were to do that, withdrawing, if one of your students did that, you would have to re-educate that student, right?
I would have to tell them to look at the scans.
Because you would never accept it, ever, if one of your students deviated from the standard of care, knowing that there were films, and chose not to even look at them. True? That would be an abuse, wouldn't it?
It would be a departure.
Doctor, it would be a gross departure. Can we agree on that?
We can agree that it would be very gross.
The bottom line is, all you're doing is you're taking it and you're just walking the witness out on that tightrope that I'm talking about before, and you knock them off, and they fall hard. Okay? The point that we're making with cross-examination is you're in control. If the witness tries to weasel out, you saw that I was trying to weasel out at some of them, everyone was listening to every single answer, and that's what you've got to do. It's what Judge McKeon was talking about before. When the witness throws you a curveball, you've got to come back with that.
Well, this cross-examination actually underscores something very important in direct examination. You heard the cross-examiner ask the doctor about being compensated. That has to be covered in the direct examination of the doctor. That doctor has to explain and say right up front that he's being compensated or she's being compensated, and what that compensation is meant to be, so that you have that explanation before the cross-examiner can get at that doctor with that line of questioning. And other areas that you can kind of, muffle the blow, so to speak, in direct examination, that's the place and time to do it.
Okay. Now, think about what Judge McKeon just said. He's talking about trying to really diffuse what's going to come across. He's telling you to take the wind out of your adversary's sails if you can. I'll put it to you that way. One of the things that you're looking to do if you're cross-examining a witness like this, Evan started to do it, agreed, because of limitations of time. We couldn't go into the collateral attack that much. But let's assume you're a clever lawyer on direct. You know that this is going to come up, that this is a witness who has testified again and again. This is a professional witness. I won't call him a whore, because that's not what we should say in court. This is a professional witness. Okay? So we know that this witness comes into court many times. If I bring that out, doctor, have you been qualified as an expert before?
Yes.
Tell the court and jury how many times you've been recognized as an expert in the courts of the state of New York.
250 times.
And during that time, has that been throughout your career?
Yes.
Doctor, have you been paid?
I have.
Doctor, is this also time away from your office? Objection leading. Doctor, tell us why it is that you're paid. In other words, let the doctor explain.
I'm being paid for time away from my patients. I could be doing surgeries now. I get a lot more for being in court.
All right.
It's time away from my patients.
All right. So let's show you the way the collateral attack now goes. Knowing that you had something like this, you were clever enough to bring it out. One of the things that you're trying to do is you're trying to reach, and you're trying to milk it for all it's worth, collateral attack. We want to show that this witness is not worthy of belief. You shouldn't believe him. He's just doing this basically on an assembly line, right? You can go back and forth to substance and collateral. Doctor, you wanted to review the MRIs, true?
I did.
You knew it was important, right?
I did.
Did you ever say to the attorney that hired you, I am not going to render that opinion unless I see those reports?
No, I did.
And that's exactly what you wouldn't do in a hospital, true?
That is true.
And that's exactly what you wouldn't teach your students, right? So let's focus on how many of these independent medical examinations you do. By the way, you call them independent medical exams?
I just call them exams.
I see, so when it reads at the top, independent medical examination, that was just something you put on it for the heck of it?
This is what they make me say.
And the reason they make you say it, let's see, independent, because the other lawyer hired you, right? The defense lawyer hired you, right? The defense lawyer paid you.
Yes,
The defense lawyer provided you with records.
yes,
The defense lawyer is paying you to be here today.
yes.
I never spoke with you before, right?
They're independent of your clients.
Doctor, let's focus on the number of these exams you do per week. You do about 5 a day?
5.
5 days a week?
5.
Get about 500 per exam?
1,000.
1,000 per exam? 5,000 a day?
Yes,
25,000 a week?
yes.
Not a bad living, right?
One that I would continue to do.
You certainly want this to continue, don't you, Doctor? Because one of the things that you'd like to do is make sure that this lucrative work you do, not treating patients, continues, right?
Yes.
In other words, what you're doing is you're getting the jury angry.
No, I think I have to take a shower now.
The point that we're making is there are ways of, again, you're working the witness out on this tightrope through collateral attack, through substantive attack, and all we did was you're working on one thing that was missing. Okay, that's the one thing that was missing from the report. The doctor even put it in. I've actually seen.
Let me ask you then,
Yeah.
would you allow the doctor to look at the MRI if it didn't have the obvious herniation that's there? In other words, you always run the risk, if you show the MRI, of losing the benefit of his not having seen it. I mean, your adversary can get up and say, he's going to look at it right now, Mr. Rabinowitz. So I assume that you're going to let him look at it because in the eyes of the jury, they as lay people can see it's so obvious that there's a herniation that you're belting them both ways. But if it wasn't quite as obvious, if there was something to talk about, would you be as quick to let them look at it and talk about it?
Now, it's a great question. Think about it this way. What are we going to do with this? We might be in a bind, right? All of a sudden, we know that this herniation doesn't look like that. In fact, it might not look like it at all. What do you do? As far as I'm concerned, the jury is waiting for you to meet that head on. If you don't show it, your adversary now has an argument on summation. Why do you think Mr. Rabinowitz didn't show that to the expert? Why do you think he didn't bring it up? So I'm going to do it anyway, but I'll do it in a different way. Doctor, I don't have to show you the MRI right now. You're going to come in here right now and you're going to say, here it is, the herniated disc, right? Right?
I want to see it first.
Well, I don't even have to show it to you. You're going to say it's a herniated disc, aren't you?
If it is a herniated disc, yes.
Doctor, you've already testified it's a herniated disc without ever seeing the disc itself, true?
I've testified that it wasn't.
Doctor, let's take a look at your report. Here, we can be clear. No herniated disc, right?
Yes.
The MRI, do we have to even show it to you to have you say the same thing?
I'd be happy to look at it.
How much are you paid today?
Not-
Now I'm going to go into the collateral attack. It doesn't matter. The point that I'm making is, I know if I don't mention it, if I don't say something about it, I've hurt my own credibility. So I'm going to bring it out. I've got to bring it out. If I don't do it, I think I've hurt myself.
If I could,
Yeah.
as to the way I would handle that, if I thought it was equivocal or there was nothing there, what I would do is, I know Ben does this too. You've learned about hypothetical questions with experts, okay? Use it on cross-examination, and not just for direct examination. I want you to assume, doctor, that my client, his doctor came in, looked at the MRIs, and he said that's a herniated disc at L4-5. I take it you would disagree with that, right? I want you to assume, doctor, that his radiologist, the neuroradiologist who looked at those films, came in and showed the jury the MRIs. And he also found that there was a herniated disc at L4-5. I take it you would disagree with that too, right? So what I would do is I would go back to my direct case. I would talk about all the good stuff that my experts found. I probably wouldn't confront him with it, although to tell you the truth I would, because that's just my personality. And by force of personality, even if there was nothing here, I would show the jury, because I got to be confident in my case, that I have two witnesses who said it. You'd agree, doctor, that that's a herniated disc, right? No. I don't care what his answer is at that point. That's just another way of doing it. I'm not saying that you should do it that way or everybody else, I'm saying that is something I think you could consider, because they're in evidence. And the jury's going to be curious as to why you're not in front of the witness.
Well, of course, the other component of this, and very often, one of the principal reasons why the doctor never got the MRI films is just plain carelessness in the defendant's office. In so many cases, just, never got them. And so I think you have to be prepared for the possibility that when a defendant calls the so-called independent medical examiner, and that's what's going to call him because that's the one who had the doctor look, those MRIs would have already been in evidence. And so you have to be prepared for the possibility that when you ask that question, before the doctor took the stand, he kind of put them up against the light and said, yeah, I looked at him this morning. So that's the other little nuance that, can come into play.
Evan, why don't you speak about use of hypothetical questions on direct as well?
Okay. So you know about hypothetical questions. In the olden days, even before I was practicing law, if you put an expert on the stand, you had to ask a hypothetical question. Okay? In other words, you had to ask the witness to assume certain facts as being true before you ask their opinion based upon those facts. In the federal rules and even in New York State, you don't have to do that. What do I mean by a hypothetical question? Let's say I have my doctor on the stand, and a hypothetical question is asking for an opinion based upon facts. Although we don't have to do it anymore, it's a great opportunity that we have to make a summation to the jury in the middle of the case. So what I would do is I would sum up in my hypothetical, if that's what you're asking. Okay? So Dr. Rabinowitz, I want you to assume the following is true. I want you to assume that my client was sitting in a car at a traffic light, minding her own business, on her way to church. And suddenly, and without warning, a car struck her from behind. And although she had a seatbelt on, her back violently was thrust backwards and forwards to the point where she felt a pain that she never felt in her life. And the pain wasn't just in her back. It actually started radiating and shooting down her right leg into her toes. And she was very concerned. When the ambulance came, they took her to the hospital. And the hospital did x-rays. And then the hospital gave her morphine because of the pain. But it didn't stop, doctor. And I want you to assume at the hospital, they actually did an MRI that showed the reason that she had this pain, unremitting, shooting down her leg. Because they diagnosed a herniated disc at lumbar level 4, lumbar level 5. And as a result, doctor, she found you, a preeminent back surgeon, neurosurgeon, who confirmed the diagnosis and has been treating her for the last 3 years. My question, doctor, is, do you have an opinion, to a reasonable degree of medical certainty, as to whether or not that rear-end collision was a substantial factor in causing this herniated disc?
Yes, I have an opinion.
And your opinion is what?
My opinion is that that accident, as you described, was the cause for the herniated disc.
And in the old days, many of the old timers would intentionally misstate a fact in the hypothetical with the hope that they'd get an objection which would be sustained so that they could repeat the thing all over again.
But Ben and I would never do that.
That's what they said about it. There was a Wigmore, remember that evidence professor? He said it was hypothetical questions were abused by the clever and misused by the clumsy. And that's true. But you can use it on cross-examination also, so I'll just switch it around just to show you. All right? Doctor, I want you to assume, this is cross-examination now, of the doctor who said there's no herniation. Doctor, I want you to assume these facts is true. I want you to assume that my client did have an MRI scan. I want you to assume that that is the MRI scan that you would have liked to have seen. And I want you to further assume that that doctor, in fact, had reviewed the MRI. The radiologist said, indeed, there was a herniated disc at the level L4, 5, lumbar vertebral disc 4 and L5, same thing. Doctor, knowing that another doctor who had nothing to do with this case at all, knowing that that doctor found that there was a herniated disc after reviewing it, would you be concerned about looking at that disc, knowing that, first of all?
Want to look at the MRI,
Would you want to look at the MRI?
knowing another doctor found it?
Yes.
No, because I did a clinical evaluation this year in the symptoms.
So no matter what the MRI said itself, you didn't care to look at the MRI, right?
We need to change our symptoms.
And in fact, doctor, we can agree that symptomatology is based on a moment in time, correct?
Picture in time.
A picture in time for one instance when you did an evaluation, correct?
That's
So you don't know what happened when the doctors that were treating her evaluated, correct?
That's true.
And you didn't care about that.
Well, it's not that, yeah, no.
So now you know, because I've given you the information, knowing that at other points in time, other than the one time that you did an examination, that there were the symptoms that you were looking for, would that change your mind? Or are you going to stick to it, saying, no, it doesn't matter?
It wouldn't change my mind now.
In other words, it doesn't matter, because what you're doing is you're still working with the symptom. Okay, the point that we're making is, you've got to continue to work through this. Whether it's a direct or cross, the hypothetical question, I know, I just asked Judge McKee, and you've actually gotten some of the materials that we've written. We try and use these in there. All right, we don't have a whole lot of time left, but I do want to go into one other area if we can. Let's assume we have an exhibit like this. Can everybody see this? Let's assume it's a simple case where somebody is crossing in a crosswalk and they get struck by a vehicle. Okay? As simple as it can be. All right, let's assume Evan happens to be a witness who saw a client get struck by, just move this around. Oh. How's that? See that? Can you see that? Can everybody see this? All right. One of the things that I want to point out is, if we're going to do a direct examination, I've told you this, repetition wins cases. But one of the best ways to show how to win a case is, if you can tell the story once without the exhibit, tell it again with the exhibit. Why? Because it's going to emphasize the point. I'll talk you through this as we go, so you can see the way we can do this. But I can do a direct examination without leading, without asking any leading questions of this witness, to allow the witness to speak. This is a witness who happened to be in the area. Let's assume this witness, Evan Torgan, happened to be in the Starbucks store, and he actually saw the client crossing with the light in his favor, truck hits through. Okay? Something simple like that. All right? Mr. Torgan, let me direct your attention to June 12th, 2012, at 12 noon. Where were you?
I was in Starbucks,
What were you doing in Starbucks at that time?
having coffee, looking out the window.
At that time, 12 noon,
Yes.
describe the weather conditions outside.
It was a beautiful, clear day.
Tell us what you mean by a beautiful, clear day.
70 degrees. Sun was out. Birds were chirping. It was beautiful.
Describe the roadway conditions at that time.
There was what I would call typical traffic on Columbus Avenue.
When you say typical traffic, tell us what you mean by typical.
I mean that there were a lot of cars.
Now, is that good enough for you? A lot of cars and a lot of trucks? You know? Tell us what you mean by a lot of cars and a lot of trucks.
What I mean is the traffic flow was constant, that all lanes were filled with either cars or trucks. They were moving along and stopping at lights.
Describe the roadway in the area in the vicinity of Starbucks.
In terms of the lanes, 6 lanes, 2 parking lanes on each side, 4 moving lanes.
What, if any, pedestrian walkways were there in the area?
Well, there was a crosswalk. There was a crosswalk crossing Columbus, and there were crosswalks crossing 67th Street on the east and west side of the street.
I'd like to focus your attention on the crosswalk itself, the one that crosses Columbus. Describe that crosswalk in detail.
Well, it was a rather typical New York City crosswalk with 2 parallel lines next to each other, with lines going perpendicular to those parallel lines. And I would say it was about 14 feet wide and about 30 feet long.
What, if any, traffic control devices were there?
There was traffic lights hanging on poles and walk, do not walk signs.
Tell us what you mean by a walk, do not walk sign. In other words, you're going to go as far as you have to support your argument. But let's move forward right now, right? Let me direct your attention to 12 noon on June 12, 2012. Tell us what you saw at that time.
Well, I was staring out the window, I was looking out, and I saw pedestrians start to cross, actually 2 or 3.
When you saw the pedestrian start to cross, what color was the light for the pedestrians?
Pedestrian had a green light, meaning it had a walk sign.
Continue.
And when I say it was a green light, the walk sign was white, and it was still not flashing. And it actually just started, it just turned to walk.
When the light turned to walk, tell us exactly what you observed.
I watched this young woman starting to cross the street, and I would say she got about halfway across, and she was struck by a truck.
Before we describe what happened to her, tell us what she was wearing.
She was wearing a yellow dress with spiked high heels, fishnet stockings. I don't remember anything about it.
Never know what's coming with it. And what did the stripper do that? Please continue. Tell us what happened as she crossed the crosswalk.
Well, as she was crossing, all of a sudden I saw this huge truck just barrel through the light and hit her. Basically, hit the left side of her body, knock her down.
I want to take you back in time just before this truck struck you. Where was it that you first noticed the truck?
I noticed the truck as it failed to stop at its light. And I said to myself, Evan, this truck is going to go through that light. And it did.
Before you said to yourself, Evan, this truck is going to go through that light, what was the woman doing?
She was just walking. Just walking.
Tell us, step by step, exactly what happened.
Well, I noticed as I was watching her walk, that as the truck went through the light, she looked to her left and tried to avoid it. But there was nothing she could do. And she got struck by the front.
All right, now, let's assume we've completed this, and now we want to use the exhibit. All right? This exhibit has not been shown to the jury yet. It's not been shown to anyone. You have to lay a foundation, you put it in. It's a straightforward foundation that we're going to put in. With the court's permission, Your Honor, may I have this marked for identification?
You may, sir.
Sir, I show you what's been marked as plaintiff's 1 for identification. I ask you to take a look at that. Do you recognize
I
that?
do recognize it.
What do you recognize that to be?
It is the intersection of 67th Street and Columbus Avenue, right near the Starbucks, where I was sitting.
Is that a fair and accurate representation of 67th and Columbus as it existed on June 12, 2012 at approximately 12 noon?
Yes.
Your Honor, I offer this in evidence.
Exhibit 1 for identification is now admitted in evidence, so your court reporter will go off in court.
Let's assume it's not marked. Plaintiff's 1 in evidence. Mr. Torgan, I'd ask you to please come up here if you would. Using the exhibit, would you please? Now, I want you to know, this is where I see too many lawyers screwing up. It's the marking of the exhibit where they screw up. So don't ever hand a witness a pen or a marker until you're sure you know they got it right. All right? Mr. Torgan, would you please show us where Columbus Avenue is by pointing to Columbus Avenue?
Columbus Avenue is this, right east, north and south.
Would you just show us on the roadway, sir, instead of the building?
Oh, it's right there. Yes?
For clarity, Mr. Torgan, would you please just write, now, I know a lot of people like to say, would you just write a C for Columbus? Don't do that. Write Columbus right on the exhibit where Columbus Avenue is.
Sure.
I'm sure. Why? Why do I want to do that? Anybody know? What's the answer? Okay, but more to the point, yeah? The jury's going to have it in the jury room, right? I want this thing talking to the jury. So that's why the way you mark this exhibit is crucial, all right? So he's marked at Columbus.
That's right.
Good. Now, would you please show us where...
It's leaking?
No.
Over me?
Go ahead.
Get Tom on the phone. We need to shore up this room, Jim.
We need Judy to help us out.
You know, it didn't leak at Hofstra, Judge, I gotta tell you.
So much for a bright, clear day.
All right. Mr. Torgan, would you please show us where you were at the time that you saw, by pointing first, don't write anything, point where you were when you saw this woman get struck by the truck.
I was right here.
Would you please put your initials ET in the area that you were when you saw the woman get struck? point out for us where it was that the truck made contact with the woman. Point first, so we know.
Point first.
Point first. Would you put a big fat X right there? Okay, now how about this question? Supposing I want to use a summary question. This is one of the things that I want to see you do with exhibits. It's terribly important, and it's powerful. It's reinforcing things. I can't just say, Mr. Torgan, tell us again what happened. Because if I say, tell us again what's happened, what's the objection? Ask and answer. But how about this? Mr. Torgan, using the exhibit, show the court and jury exactly how the accident unfolded. Okay. Objectionable? No, I never said use these, right? Using the exhibit. And that's,
I was sitting here where it says ET, looking out the window. This was a beautiful day. And I noticed this woman crossing the street in black fishnet stockings. And when she got halfway across, right here where I put the X, that's where the truck hit.
you can mark it any way you want. You can put the truck, you can put the woman, you can put where they ended, where they landed. The point that I'm making is if you're going to use an exhibit, make sure this exhibit talks to the jury in the jury room. When you're not there, you've used it on summation, if it goes in, and a lot of the courts will allow the exhibits to go right into the jury room, tell them in your summation, take the exhibits in, examine them, evaluate them, especially if you've laid it out. Other thing is this. On cross-examination, Judge McKeon was telling you have to be prepared for the cross as well. If your adversary is going to come back up and say, would you please put an X where the traffic light was, please, you can't do that. You've got to be mindful of it. So what are you going to do? You'll have another colored marker, perhaps an overlay on something like this, so they don't screw up your exhibit. I'm telling you, I'm going to see that lawyers try and do that all the time. It's too important to you. Okay?
Ben, and it's a little off subject, but I think it goes hand in hand with this. To what extent, if any, will you use demonstrative evidence, for instance, in an opening statement, where you have something like this particular intersection where you know it is what it is and it's going to be subject to connection, and is it something that you do, or do you kind of let your voice do the talking and let the demonstrative evidence await a witness to speak?
I can't tell you how many times I've asked judges to allow me to use demonstrative exhibits in opening statement, and for some reason, it's almost an antiquated idea that you can't do it. You're not allowed to do this. But I will tell you where I have been able to do it, and that is where you have an issue, for example, a herniated disc case, or a complicated medical case, where there's no issue about the medical, for example, spinal model that we have here. If I want to try and explain that, it's so much easier to use a model to explain it. And very often I'll say to the court, Judge, I'm representing to you as an officer of the court that my expert's going to come in and say that this is a fair and accurate, it's actually an anatomically correct model of the human body. I want to be able to use it in my opening, my adversary can use it as well.
Well, of course, what you don't want to do is to use it without first having it cleared, only to, to be bawled out in front of a jury by a judge saying, you know better than that, Mr. Benwitz. So if that's the direction you're going to go, generally speaking, and you guys all are aware of the notion of an in limine application, presumably you would ask the judge in advance, I'd like to do this, you have a problem with the judge, and then make your spiel as to why, it's appropriate.
Spinning off on what the judge has said, one of the things that we see more and more now is the use of PowerPoint presentations in trial. And not just the PowerPoint presentations on direct or on cross, but also on summation. And I'll tell you one thing that you have to do. If your adversary uses a PowerPoint presentation for summation, you must demand to see it before they sum up. I saw one done in court recently where a lawyer was trying to argue that a witness had lied, and when he was talking, up on the board went Pinocchio. And then sure enough, as he was making his point, so he said this and he said this, and the nose was getting bigger and bigger. It was great. I loved it. But his adversary never asked to see what was going on. So you didn't even have a chance to see what was going on. And you should have made a motion at least to limit it, to try and keep something like that. It's powerful. Maybe you lose, maybe you don't. But if you don't, you've got to work with it yourself. So it's an answer to what's going on now, and especially in light of all of the technology that's being used, the smart boards, and they actually have something called Trial Master. I'm sure you've seen this on the iPads where you can actually run the entire trial through this. One of the things that we see now all the time, and Evan and I just wrote an article about this, is the use of videotape depositions, which is something we're doing now. We used to have to cross-examine by prior inconsistent statement. Nothing better than having a witness speak himself. You've never said that, have you, Doctor? No. There it is. Let's play the exhibit. It's what
Well, of
works.
course, when I was first breaking in, jurors didn't have an expectation of demonstrative evidence. Today they do, because the world has changed and the nature of the cases have changed. Medical malpractice is so advanced today that, you have the accessibility of experts who can very much speak to and make simplistic and understandable a lot of terms that are quite complex. Years ago, because you didn't have these kind of cases in the abundance that you do today, the rules of evidence didn't develop to deal with these particular nuances that you see in the courtroom.
All right, questions?
That's insulting, no questions.
Thank you.
I was curious, when you were doing the hypothetical, what happens if you get like an objection on witnesses, counsel is testifying?
That's what a hypothetical question is. It's got to be based upon the evidence. So it has to be true, or it has to be what somebody's testified to, what somebody's shown. So you have to be really careful. You really do want it to be accurate, because you don't want to look like you're trying to mislead the jury. But just make sure it is true, or it's true based upon what the testimony is.
It's a very fine line, and it takes a great skill to ask a good hypothetical question, because you can readily come across as a bore if you ask a question that seems to have no ending to it. I think the point that we're making is that in the old days it was required. Today it is not. But it is still available to you in the right set of circumstances and can be a very effective weapon if the facts of the case let you testify in asking and you're using it with an expert. That's really where it's most used, because you're asking the expert to assume certain things that have happened in the courtroom and are in evidence.
I want to ask a question sort of on everybody's behalf here, which is to say that, you guys are experienced lawyers and you've been doing this for so long, and you do it so well. How are you best able to accomplish what Judge McKeon was mentioning at the beginning, the sort of narration of the story, which is to say, that when you're up here now, you have to be listening to what you're doing, not as the people you are, but as those people who are sitting in the jury box, who know nothing about this case, have none of your background, have none of your experience. So how is it that you can sort of frame all your examinations and the story you tell in a kind of slow, step-by-step way, where you're anticipating the questions that they're going to be asking about the case?
I'll answer it this way. I started to say before, a trial is a dynamic thing. It's not static. It's always changing. So one of the things that we do is, yes, we prepare our entire trial before we even start the trial. You'll do that too. But what happens is, we start the trial, and one of the very first things that happens is, we might open first, where the plaintiff's defense then goes. I'll order the defense opening. Based on what the defendant's lawyer has said in the opening, now we're going to change things around. So it's always changing. It's changing in the midst of an examination. So you've got to be quick on your feet. And that's one of the reasons I was suggesting before. You know what you said in your opening. That's your promise to the jurors. You better keep that. I don't care if you're a plaintiff or a defendant. When they tell you you don't have a burden of proof, if you've opened, guess what? You do. And you have to make sure that you live up to that. So the point that I'm making is, if you're really thinking it through, you've got to go not just to what you're narrating at the time you're narrating it, but you want to be able to support the summation. And that's why I keep saying to you, take a look forward. Look forward. What is it that you need to say on summation? And if you can get there, if you can make your points clear, you've done your job. You will get there.
What I would say in response to what you're saying is, Ben and I, most people, are very detailed opening statements. So you never want to overstep what you can prove. You never want to do that. But everything that we did on direct would have been discussed in opening statement. So for example, that scene of the accident, the jury would have known all about at least the picture in their minds of the scene of the accident. The Starbucks, the crosswalk, the type of day it was, without referring to a specific witness, which is bad form, because God forbid, they would have said, never mention witnesses. Even that MRI of the spine, that would have been a detailed opening about 5 lumbar vertebrae, 12 thoracic vertebrae, 6 cervical vertebrae, and the discs having a nucleus pulposus. As boring as that sounds, you really do have to educate them to get an idea of what they're going to expect. So when they hear the witness say it, they've already heard it. And when they see it, they already have in their mind's eye what it looks like. So the key is not to be boring and to keep everybody alert and awake as best you can. But I think it's the detail.
Well, the great trial lawyers have their summation in their mind before they ever walk into the courtroom. And the ingredients that go into that summation are what they hope to achieve in the courtroom. In other words, the opening, the introductory, kind of piquing your interest, giving you an overview of what's to be anticipated. The ingredients, the parts of the stew that are going to be mixed in the pot, and then the serving of the stew in the summation. Hopefully everything having to come together, and they being able to say to you that which they hope to be able to say to you before they ever walk in the room.
Earlier in your career, what skill or tactic was most difficult for you to develop, if any?
It's a good question. I'll tell you one of the areas that I still struggle with, because it's just an unknown. You can prepare for your OT, you can prepare for your courses, but jury selection is a very difficult area, because you never know what you're getting, and you never know what the jurors are thinking. And the dynamics have been changing all along. We never even, when we started practicing, I didn't know what Generation X was. I didn't know whether or not older jurors were the types of jurors that would help or hurt, or whether or not they would somehow destroy your case. What are the different areas that you want? What about the, you think about, what about the race, religion, creed, color? Does that affect the jury selection? And there are so many things you just don't know, and you're so limited in time. So trying to master this in a very limited amount of time, especially when the courts are saying, counsel, you have a half hour to select each jury. What are you going to do with it? What do you have to do? So to me, that's one of the more difficult areas.
It was all very difficult for me because I didn't take a trial class, and I didn't take the NIDA course, and I didn't do any of this trial competition. And when we were at school, Ben did. He was a year ahead of me. But he had a background in it, and I came out, and I tried my first case pretty much the month I was admitted, and I had no idea what I was doing. So to answer your question, it was all difficult. Nobody was teaching me the first 8, 10 trials. I went home with the Mowat book. Did I still use that? I read this chapter on jury selection, right? I stayed up all night freaking out. I went and I did it. I went home, I read the chapter on opening statement. Okay? Then direct, then cross. I did. That's how I did it. It was absolutely crazy. It's absolutely nuts. So what you're doing is, if this is what you want to pursue, and seriously, it's the greatest thing in the world. Very few lawyers love what they do, but I can tell you we love what we do. And I can tell you he loves being a judge. This is really cool stuff. And you help people, and you compete, and you do well. So anyway, what I'm saying is, it was all incredibly difficult for me. And I agree, the jury selection, even to this day, it's the whole case. So it's the scariest. Because nowadays, cases are basically stipulated sets of facts. The facts are the facts. And who you pick on the jury, to be on the jury, is going to decide that stipulated set of facts. And I'm convinced of it. So that's why it's the scariest part for me.
I think what you're doing tonight overcomes something that most young lawyers confront, and that's a comfort level in a court. That kind of fear of the unknown. And it is unknown because you haven't done it. So, you're doing what you're doing now helps you to bridge that particular knowledge gap that is so very, very important to allow you to feel comfortable when you step into a courtroom for the first time, and seem to allow you to appear to know what you're doing. And you never learn enough about this. That's the fascination about it. Each new trial makes you a bit more wise.
It does. It does. I like the question, and I'll tell you something. I wish, when I was in law school, I wish I had the opportunity to have what you have right now. Thank you, Judge, because you brought something to this school that I think every law school should have. And why not? You have practicing lawyers coming in and try and show you what they know, what they've been through. You can learn from our mistakes, and we can show you what we've done. Judge, thanks.
Thank you.
very pleased that you didn't get wet.
I wanted to take a shower and
And we will see you all October 3rd.
Thank you.